understanding the technology that powers the money is essential. Knowing the business drivers that inspire how the money is made is crucial. Bridging the gap between the mind of the technologist and the mind of the business is monumental. That is what TBF is all about. Let's start this never-ending conversation. It's time.
Welcome back for another episode of the Tech Behind FinTech. I'm your host, Deontea. Joining me today is Carolyn Michel. How are you doing?
I'm doing fine. Thank you for asking.
It's good. You know, it's been a while since you've been back on the show. You're a returning guest. Today, we're going to go into MiCA Unpacked, how EU regulation is reshaping crypto markets. We know a lot of regulatory stuff are coming up. So this will be a very great conversation to really dive into it with your expertise. Before we jump into the show, let's just do some housekeeping. We are streaming from Facebook, LinkedIn, YouTube, Twitch, and those are our channels. So even though Carolyn's a returning guest, still have to read her bio. She's the co-founder and head regulatory analyst for Deontea. I've always mixed that. I'm going to make sure I have it correct. Deontea, correct?
That's right.
All right. Apologize for that. So let me get into Carolyn's bio. Carolyn Michel holds a master's degree in economics and postgraduate diploma in compliance management. After leaving the financial market, she held various positions as a senior compliance executive. Before joining the Financial Conduct Authority, she is instrumental, among others, in drafting the numerous section of the Commission Delegated Regulations supplementing MiFID II and various L3 provisions such as ESMA Q&A on investors' protection. So, Carolyn, welcome back to the show. Today, we're going to get into MiCA. For those that don't know, can you give an overview of what MiCA is and what's going on?
First, it's very simple. MiCA stands for Marketing Crypto Assets Regulations. So basically, it's dependent regulatory instrument for crypto assets in Europe of MiFID II, which is the one for financial instruments. So that's the choice that the European Commission and basically the European Regulatory Authority did, was to draft a specific tailor-made regulatory instrument for the crypto assets and obviously the crypto asset service providers. Instead of trying to qualify the crypto assets and integrate them in existing regulations, they actually choose to do something which is specific and tailored for those needs. So that's MiCA. It comes into force the 1st of January 2025, but there are many exemptions, grandfathering periods, so maybe we can go through those later on.
Yeah, so, the reason this is so important because it looks like it's going to impact every single crypto firm in the EU. Is that accurate?
It's very simple. Is if you are providing, I know that in the US it's slightly different, but let's say for the sake of making it clear and easily to understand, when you're providing financial services or what we can call financial services in crypto assets, you will have to hold an authorization from a national competent authority within the EU. So there is no way you can continue providing those services from outside the EU or within the EU if you are not properly authorized to actually do so. It's like, if you're providing investment services, if you're providing payment services or any other services within the financial area, but you will need to get authorized.
Pretty straightforward. I mean, at this point, this is going to be the regulatory standard if you are providing any type of crypto services in the EU. Even if, right, what if you're a US-based company coming into the EU? Does it still impact you?
Yes, it does. It does, because it's exactly the same thing like for any other situations, is that if you serve EU customers, you need to abide by EU laws. So let's say that you are a US company servicing EU customers for, I don't know, derivatives, securities, standard securities, you still have to hold some type of authorization. Now the US are slightly different because there is something which is called an equivalence decision. And for certain of those services, they can do so from the US into the EU under certain conditions without having to be authorized in the EU. But that's a very limited scope. The other, most of it is like in the US. It's exactly like in the US. Let's try to service US customer from Japan, from the EU, or from the UK without holding any type of authorization. I don't think, your authority will be very keen for that.
Of course. So January 2025 is when it's going to be introduced. I assume a lot of companies are scrambling to get things in order. Would it allow for like a grace period? Like at what stage do you have to be by January 25? You're a crypto.
This is what I wanted to say. Actually, there are a couple of exemptions. So, grandfathering period, you would call that, is that companies that already hold some kind of registration, authorization, depending on each member state, will be able to use that grandfathering period until the 1st of June 2026. Okay, but that will limit their ability to provide those services because they will only be able to provide those services within the country where they hold that specific authorization registration. I know that many US companies actually have some of those in various member states, so that might allow them to keep on doing the same type of business they did previously, but they will need to be very careful because it cannot be done on cross-border basis. So let's say from France to Belgium or from Germany to Denmark, they will have to have, if they want to service Danish customers, they will have to have something in Denmark, in Germany, and so on. One of the reasons why the EU regulatory framework is so interesting is effectively it provides for the fact that you can hold one authorization in one of the member states, and with the passporting rights, you can actually provide those services across the entire European Union. In this case, we kind of coming back to what it was before, like before 2008, like right in the 90s, early 2000, where basically you need to hold an authorization in each of the member states where you want to provide those services. And for those who don't, then you need to actually really speed up the process because you have to hold an authorization on the MiCA at January, on the 1st of January 2025, because then you won't be able to continue servicing your European clients.
Based on what you do in terms of your company being that authority and assisting clients in these regulatory matters, I assume you're extremely busy.
Yes and no, because European, the thing with regulation is that it's something people don't like. They actually really dread being authorized. They dread to have to answer to any type of authority. And in the tech environment, it's even worse because they think that their product or their technology is driving basically, the company, the services they're providing and what they do. Unfortunately, in the regulated space means in any activities that are subject to licensing, it's the opposite. It's the regulations or the license that drives your ability to provide the services. So yes and no, because yes, in the sense that there is a lot of inquiries from the UK, from the US on that side. Some large companies already got authorized because I just said that effectively the bulk of MiCA comes into force the 1st of Jan 2025, but everything which is related to stable coins came into force in June. And basically, there is already, some companies got authorized for that, the US Coinbase. So it's quite interesting. Stable euro, yes, it's a euro stable coin. But they didn't get authorized on the MiCA, they got authorized under the payment services provision, because stable coins is about actually providing prospectus, not being authorized as a person, basically transacting in those. So it's a kind of a bit complex, but let's say that coming back to the mainstream, for European companies, a lot of them are struggling currently because they tried to get, they are trying to go towards authorizations, and it's complicated. Now, don't forget that there is something different that exists as well in MiCA, which is the fact that entities that hold an authorization or a license to provide standard financial services, let's say a credit institution, a payment service provider, an investment firm, or an asset management company, they can actually request a variation of permission to add crypto assets to the offer they're providing to their clients. And that is a totally different route that currently authorized firms and licensed firms are taking also, because as you know, crypto assets are now, I wouldn't say mainstream, but this is something a lot of investors are asking. So instead, they're just adding another layer of products or services to the currently available one.
So in that example, a few questions, right? So number one, right? I'm currently a financial services firm, helping high net worth individuals, with their assets and so forth. But now we're adding a crypto component. It could be a, crypto ETF. It could be whatever, something that they might not be buying Bitcoin directly, but they buy it through us in some sort of commoditized package, right? And we sell it. When we add that service on, even though we're not a historically crypto-based company, but we are adding this crypto-based product for our clients, then just to be clear, MiCA still applies to us?
Unfortunately, you choose the two examples where it doesn't, because an ETF is actually an investment fund. So irrespective in what it is invested, it's still a financial security. It's still a financial instrument for the purpose of the regulatory framework in Europe. So MiFID applies. That's one thing. Bitcoin is out of scope anyway. So we are just kind of like really in the middle. That's the point. ESMA is clarifying those concepts. The thing is that we talked about crypto assets. Crypto assets, first, we don't talk about cryptocurrencies because this is a wording that doesn't exist. From regulatory purpose, only crypto assets do exist. Crypto assets, it's a very wide, and let's say, it's wide. The scope is wide. Here, some of those crypto assets are actually real financial instruments. So MiFID will apply, or any other rules may apply. What we're talking about? We're talking about tokenized securities. Tokenized securities keep on staying securities. So the standard financial rules apply. Funds are funds. Funds are, collective investment scheme. The one like AIFs, means alternative investment funds in Europe, can invest in anything they want. So in that sense, they can invest in crypto assets, but they remain in a collective investment scheme. So the IFMD will apply and still applies. So if you are already authorized, but you can provide those services. So it's a bit more complex on that side. Now, all the rest effectively will fall within crypto assets perimeter, means in the MiCA perimeter. And again, there are certain issues like NFTs, because the ones that are fungible will fall under the scope of MiCA. The ones that are not fungible will fall under this, will be outside the scope. That will be a work for the future. So let's come back to something more simple. You are just a broker, an investment firm, a trading platform that is authorized to provide financial services or trading securities, because this is the term used in the US. In Europe, we call them financial instruments. Then you will need just to liaise with your regulator and ask for a variation of provision, variation of permission to add those assets to the scope of financial instrument you can offer. So it's a slightly lighter, basically, route, in the sense that it's just only part of your system's controls and arrangements that will have to be modified, because you will still have to explain to the regulator how you integrate this. Do you have enough resources to be able to take care of this new service? Do you have the knowledge and expertise to be able to provide those services? But obviously, all the rest is already in place. And in that sense, it's quicker, cheaper, and usually more easy to do, in the sense that you are an expert firm in that. So you are already authorized, you know the rules, you know how you are supposed to operate, how your governance works. And in that sense, normally it's a much more, I would say, it's an easier route. Now, there are some firms that already are authorized to provide crypto assets, because certain countries like Germany or even France have already put in place an authorization regime, not a registration regime. It's a slightly different. And those firms hold a full scope authorization from the local authorities, like, for example, Société Générale Forge. And here, MiCA provides for a quick authorization to move from the national regime to the MiCA regime, which will provide you with passporting rights. There is a lot of routes. So the thing is that is really, when a firm wants to provide those services, the first thing they need to do is call us, obviously, is basically ensure to know what they do, what they want to do, and from which position they start. Because there is not one route to actually achieve what they want, means providing those services in crypto assets.
So simple question, because I'm sure we're going to have an audience member that asks this, right? Because sometimes people get to distinguish between crypto assets and cryptocurrency. Can you help me with that? Let's make because it's like, if it's
the regulatory regime, regulatory regime in EU, there is no such a thing as a cryptocurrency. As soon as something is based on the ledger, the distributed ledger technology, means the blockchain for everyone, then it's considered as being a crypto asset. And actually, if you read MiCA, you will see it. This is the way it's defined.
Okay.
Now, some of them will be considered as financial instrument, as I told you. Some of them are outside of the scope, and some of them are effectively in the MiCA scope. So as you see, you really need, compared to maybe some more traditional activities, to be supported by a firm that will clearly help you out figuring out where you stand, because that saves time, that saves obviously resources, because it's easy to take the wrong route. And once you actually invested in that, in this process, changing in the middle because you're figuring out that actually it was the wrong one, it happens even in traditional finance, is something that is better avoided, because it's waste of time, money, and resources.
So a few questions, because so something like Bitcoin, you said, is out of scope.
This is a bit more complicated than that. Is a bit like FX, when you are a firm that provides, because usually the way a regulatory framework works is there is a description of the service you're providing. So it might be trading, it might be dealing on an account, it might be investment advice, it might be portfolio management, it might be many, many things, payments, and so on. And obviously, that's the first thing, is the service, and then it's the product. And some regulatory frameworks work like only the service qualify for licensing. Some either work like only you need the service plus the product to qualify for licensing. And MiCA is a bit complicated framework because, as I told you at the beginning, you choose not to qualify specifically the different assets, but to say, okay, everything which is crypto will fall under it. And they put there various regulatory regime that we have in traditional finance, because it covers obviously everything which is related to securities trading, but as well to safekeeping and safeguarding of client assets, which is CSDR or custody services and so on, but as well parties payment, but payments, it's complicated. I am sorry, it's Bitcoin might fall under it because of the service which is provided on it. And sometimes it will be outside depending on the service. But itself, as such, Bitcoin itself is not considered to be a crypto asset for the purpose of MiCA. This is the way it was. But it will be further clarified with the third consultation of ESMA that should be published in, when is it? The first, in a couple of months. Or maybe it's already out there.
So I think I get it. I'm just going to reiterate it and see. Let me see if it makes sense. So from a
it's not very clear because it's here we're really entering into the core of the issue, and basically to be able to answer you very clearly and with full certainty, you cannot just like that, because as I told you, it will be a variable depending on what you do.
Yeah, and so from an overview perspective, I think I'm getting some clarity on it, right? So if I'm a firm, right, you either have a product or service or both that you offer, and how do you describe it in this instance, right? Something like, we're just using Bitcoin as an example. There's Ethereum, there's plenty of other things, but I could be providing a service now that leverages something like a Bitcoin. From your side, it might be considered an asset, and then it may fall under MiCA, not from necessarily just a product aside. And then from a crypto asset perspective, if my firm, let's say we create our own currency or we tokenize something, then we definitely fall under MiCA. Is that?
If you tokenize something existing, except if it's pure real estate, which is not, as I told you, if it's like, if you tokenize let's say a house or a building, if the tokenization is the full building without having it split in tranches, then it will be falling outside MiCA. Now, if you tokenize that same building and it's split in tranches to allow people to buy pieces or section of that building, that it will fall under MiCA because it's considered to be fungible. Now, if you tokenize as an existing security, like, I don't know, shares, bonds, you may talk about units of collective investment schemes, then it will be then it stays as a security. So it keeps its own nature, even if it's tokenized. Because then the ledger technology is just serving as a mean of exchanging those, instead of actually being it's not the nature of the investment which is changing, is the way you distribute it that is changing.
Okay.
All regulations, to keep in mind, all regulations are technologically neutral. So technology doesn't change the nature of what you're doing or the nature of what you are. Technology is a tool. It's considered to be a tool. So why MiCA? because when we're talking about most crypto assets, their nature is being something on the, is created out of this ledger technology of this blockchain. This is their nature. So here we're talking about MiCA. Now, if you're taking anything and you're putting it on blockchain, it stays the things that you put on the blockchain. Does it make more sense like that?
I think so, right? I just want to make sure when people are viewing this episode, they're clear on it. Even from the perspective of, if I'm an organization doing business in the EU already there, how do I know? And I'm dealing with, some sort of tokenized assets and things like that, or services in that realm. How do I know if MiCA impacts me? That's really what I'm getting at. Like if I'm a firm or I want to do business in the EU, I'm doing business. How do I know if it impacts me?
It's very simple. If you provide investment services, here we're talking trading, portfolio management, investment advice on crypto assets, MiCA impacts you. That's
Even
it.
the advice?
Yes, investment advice, yes. I told you, MiCA, most of MiCA, I would say most, not all of MiCA, is dependent of MiFID for crypto assets. MiFID services are what? Dealing, transaction in securities, investment advice, portfolio management, some other things. Operating a trading venue as well. So, but it talks about financial instruments. So that's it. All right. Now MiCA is the same for crypto assets. So the question, effectively, the right is, what is a crypto asset and what it is? It isn't a crypto asset. I told you most assets that are on the blockchain will be crypto assets, but there are some exceptions. One of the exceptions, if it's as tokenized security, because a security stays a security. The fact it's irrespective if it's on the blockchain or if it isn't, because the contractual arrangement is the security. Security is a contract, first and foremost. Is the rights, it provides you rights. If it's a share, it provides you, a percentage ownership in the company. If it's a bond, it's a credit, and so on. So that stays the same thing. Tokenized shares of unit collected of investments of funds stays funds. They are still funds. They don't change. It's where they are actually registered. Now, if we're talking about crypto assets, when we're talking about crypto assets, what crypto assets are you thinking about? Like, what comes into mind? All these cryptocurrencies traded on the big platforms, they will be in scope of MiCA.
Yeah, so
I think the only exception will be the Bitcoin, because the status of Bitcoin has not been yet totally established, but everything else will fall under MiCA, just to make things, more easy. That's the starting point.
So when I think about it, right, I think about the two majors, right, Bitcoin, Ethereum. But that instantly comes,
But actually, no, Bitcoin and Ethereum are not the same. That's the point, and that's what makes things a bit awkward. And I agree with you. So I really believe that the most easiest way is get some support. Ask for it. Ask, a specialized firm in regulations in this framework to tell you exactly where. It's not necessarily very costly, but your starting point is not, I will try to find a way not to be regulated, not to be on the license, but the other way around. And you might get a good surprise, because maybe there's ways to do things which will be less heavy, less costly, less resource consuming. But believe me, I worked for the regulator. There is one thing in Europe, and this is very different from what you have in the States. You do not question the regulator's standpoint of view. This is not something you will discuss in court. It's not something that you have in the US. I know that there is a lot of litigations taking place right now to try to say, this is not a regulated service. I do not fall under the securities law and so on. You can't do that in the EU. That doesn't work. In the EU, really, the best way of doing things, and by the way, in the UK is exactly the same thing. You know, even if they don't have the regime is being made right now. They will have something quite similar to EU, maybe slightly different on the outset, but it's exactly the same approach. The FCA has the same approach. Don't forget that he was part of EU for a very long time, and most of what we have in the EU has originated on the principal part from the UK, because they are one of the oldest financial market in the sense of being as wide and as well as organized as such. So the starting point is always, I may be regulated, I need a license. The point is, which one? That's the real question you need to ask yourself. Because honestly, if you're coming from, you know, if you're asking that question, means that you have a doubt, do you? Or if a firm is asking that question, is that basically they believe that there is a potential need for a license.
Of course, like that's if your business is dependent upon crypto in any nature, and then you hear about this license need, it's like you want to understand, like, do I fall under this? How does it impact me? What do I need to do to get compliant if I do fall under it? Or maybe we don't. Like, and I think that's the a little bit of the confusing part. But like you said, you know, you pretty much need to link up with a consultant just to get an understanding.
Yes, because to be honest, you know, if those people are asking that question, is that somewhere they believe that they are providing services that, technically speaking, are kind of like, in the traditional sense of wording, because I don't want to upset anyone in this word, that they believe they are in the financial world. They're providing financial services, even if you take it as a how to say, day-to-day wording. Okay, we're not talking regulatory here. So if they believe so, it means that there is something behind it that is so. Okay, if you are just rolling an information platform, it's an information platform. You don't even ask yourself, am I regulated or am I not regulated? If you just, you know, write on the crypto markets because you like it, or you provide training on crypto markets, you don't even ask yourself. Now, if you're starting providing any type of services that will be advice, you know, providing information advice are two different things. Providing, because it will you know, it will push someone to make an investment decision. If you're providing any type of trading, you know, services, you know that you are in scope somewhere, even if you try to avoid being in, because I can understand why. Please make sure that you ask a firm to accompany you, and there you will have a certainty, a regulatory certainty. And is, as in the US, like in many countries, providing regulated services without proper licensing is a criminal offense. I would like to remind everyone, because now today there is a regulatory framework. In the past there wasn't, and it might be very costly.
And that's what I was going to ask next, and you beat me to it. What are the repercussions of non-compliance? So,
okay,
you know,
so depend your size, to be honest. Okay, so the rule is that providing regulatory services, or you know, services that call for a license without having the license, is a criminal offense in most European countries. Criminal offense is jail and fines. So obviously, you know, the regulator, like in the US, like in everywhere else, doesn't have all the resources, the means to go after every single one. We agree on that one. So if you are a small something somewhere, you may have you know, how to say, you may eventually avoid it. Now, all regulators are having a blacklist. So basically, they are listing on their websites all the firms that are providing services without having the proper licensing or registration. You can go right now. You have all the lists. You have. So this is a reputational issue as well. So you are actually named as such. And second, don't forget that regulators have a very long memory. When I'm saying very long memory, means is if in 5 years' time you suddenly decide to do the things how they were supposed to be done in the beginning, then you won't be able anymore, because the regulator has kept records of the fact that you provided services without the license, so you will not be considered to be fit and proper to actually run this type of company. And they communicate between themselves. So it's not because you are listed on the French regulator website or the FCA regulator or the Danish one and that you decide to get a license in Estonia or in Germany means that you can pass through, because all this is actually kept by ESMAT at some point, and they communicate with between themselves.
Wow.
So it's not, honestly, what's the point? If you are a serious business owner, all right, we are serious business owners. We run our firms. We try to be successful. We try to do, to have a sustainable business model. Why take the risk? I don't know. Why take that risk? Is it worth it?
I mean, based on the repercussions and the long-term and short-term impacts, obviously I would say it's not worth it. So the EU right now is leading the forefront on this, I would say. Would you agree with that?
Right.
Okay.
Yes, because they have the only fully comprehensive regulatory framework for crypto assets currently. I'm not saying, this will be the case in 10 years' time or 5 years' time. I know that the UK is putting something together as well. It's in consultation phase. Don't expect it to be dramatically different from what we have in EU, because the principles of the regulatory framework in the UK and EU are the same. They are different on the outset. There are certain differences, but they are not so much. I believe in the US is still an open question. I know. We'll see. But most countries will effectively do so for two main reasons. Investor protection, because effectively crypto assets are starting to be mainstream. And in that sense, it's important to ensure that investors have a minimum protection level. Protection is not about protecting people against themselves, it's ensuring that they have access to fair, clear, and not misleading information, that the products you're providing are suitable or appropriate for them, and that effectively you have safeguard first, for instance, claims, and that those companies that are providing those services are real companies. Because I heard from some of my friends that are working in the crypto space that there is a tremendous amounts of frauds going on right now in this space, and people are getting, funds are being stolen a lot. And in that sense, I think there is a need as well from some clarity if you want to invest in those assets, which I believe is a good investment as any other, depending on your needs and your objectives. I believe that you are entitled to a minimum level of, some framework where you actually feel safe in being able to do so. That's one thing. And the second is what we call the stability of the financial market as a whole. Why stability? Because financial markets play a very important role in the economy. And if these markets do not function in the fair and transparent way, then the entire economy at one point is impacted. So that's the role of the regulation, nothing more.
In this industry and so forth. I mean, we had countless crypto companies go down within the last few years. I mean, especially the last. So let's just take a major example that everybody knows, right? That they went down. The CEO's in prison now. FTX, right?
That's
So
right.
so let's take FTX as an example. Let's say we fast forward. FTX is started now. It's working. It's still up. MiCA came along.
Yeah.
It was regulated through MiCA and all of the different aspects of MiCA. Would certain things have been uncovered earlier?
First, certain things wouldn't have been possible. That's the thing. Not only effectively certain things would have been discovered earlier, but certain things wouldn't have been possible. For instance, one of the main issues behind FTX is that FTX, Mr. Beckman, something like that, used client assets. Used client assets and funds. Basically, you as an investor, if you use its platform, that money, you know, Mr. Beckman sent it to the other company for investment purposes or whatever, for his own needs. In a European regulatory space, in the UK, is the same thing. You cannot. Companies, they can't hold, and if they do, then they are totally differently regulated. They have to prove that those assets are safeguarded, that they're actually shielded from the operation of the company themselves. And this is actually looked at. And for asset management, it's worse. Those assets have to be actually held by a third party. They cannot be held by themselves. You remember Madoff? What was the issue of Madoff? Is that he invested assets that didn't exist. And since, and that's one of the main rules that we have, and I guess you have the same thing in the US, is that the investment firm cannot hold those funds. It means it's not there. For in the collective investment, it has to be put aside to a third party. So you have warranties that basically those assets that you as an investor are giving to the firm or using for trading purposes cannot be used by the firm for their own. I'm not saying that it's 100% bulletproof, because everybody can, it can be a fraud. So basically, the head of the firm can take the money and run. Okay, we agree on that one. But I would say that it's not a business construction. Means the operating model cannot be based on this, which was the case with FTX.
It's interesting.
You seem puzzled.
No, not puzzled at all. Actually, I was mentioning them as an example, highlighting the importance of these types of regulatory frameworks, because it actually protects the investor. And I want to just understand, based on the outcome of that situation, if MiCA was in place, what would have happened? And you just explained that. So yeah, that's extremely important. I mean, we just saw over the years so many different crypto-based companies, basically, rug pulls and just all sorts of things, and investors are left, holding the bag. And so it's a very interesting situation. What, in terms of looking forward, right? The EU is having MiCA January 2025, UK soon to follow. What other countries do you see this happening in?
Probably Switzerland, but they already have something in place already as well for quite a while. I believe that in Asia, maybe Singapore, Australia, people are really understanding now that, as I told you, crypto assets are really becoming a mainstream instrument. And as soon as you become a mainstream instrument, you impact everyone. And why is it so important? It's not because, to be honest, it's not because governments are so worried that you, Nabi or me, Caroline, don't lose money. All right. It's because if it becomes a systemic issue, they will have to step in, and they do not want to. So they prefer to prevent it. Most of regulations came in to play because they posed a systemic risk for the stability of, as I told you earlier, of the entire economy. Imagine that all, 50% of the retiree of people, that will invest their retirement funds into crypto assets, and it disappears like FTX. What do you think will happen? Do you think it, everybody may say, oh, too bad? No, you will be 50% of your retiree without any, way to basically pay for their life every day. The governments will have to step in. So basically, one of the goals of the regulations is to ensure the stability of the general economic environment. And if it passes by regulation, it does. But, the thing is that for a very long time, you probably remember 2008. Okay, everybody remembers 2008. We all think it's a financial crisis. Okay, it effectively started as a financial crisis. The consequences of it went well beyond basically the financial companies. As we all remember, we had about 10 years of very limited growth, if I would say like that. That's an understatement. So basically what happened is that at that date, all the governments came together and say, okay, we don't want to have that again because it's too costly. It's too disruptive. It's too complicated to manage. And I will lose my, I will not be re-elected, by the way, as well, but that's something different. Yeah. So let's put something together. And this framework under which we actually operating is born from that. And it's born from that, and it's born like in this current form, 7 years at most. MiFID is 2018, in Europe. Most of the rules we're working on there are 6-7 years old. So it's very, very short. So but most of us remember before. And before was financial instrument, or the financial world was somewhere outside the normal world. Was something special. We were special because we worked in the financial industry. You will not expect that from your car maker, from your restaurants, from the people doing your clothes, the people selling the water. You expect those products to be safe. You expect those products to have explanation of what are the risks, how they can be used, how they cannot be used. You expect those companies to take care and be and actually care of how those products will be used. Will they be harmful to the general public? Why should financial products be different? They are even more important because they actually dictate our wealth, our ability to pay for our kids' studies, for our retirement, to go on holiday, whatever. It's true. Why should it be different? When you're going to a restaurant, you expect the waiter to have washed their hands because you don't want to catch some kind of disease, right? That's part of your normal life. When you buy a car that actually breaks, sometimes Tesla don't, but that's something different. But even if they are beautiful cars. So financial world is the same. So, for me, it was always a question I never understood, is why people are definitely trying. Yes, it's costly, but you have a greater responsibility when you actually providing this type of services. So I would think it's normal that you take more precaution, and taking more precaution, being more better organized, being more watchful for the harm that your product can do to outside world, has a price. And that price is our regulations. Now, one thing I would like to say to brighten the scope, is you need to look at regulations as operational tool to better conduct your business. They are operational tools. They are not legal. They are something that you do in a natural way when you provide those services. So it shouldn't be a burden. Now, if you look at it from a legal point of view, which is the US West very often, and even in Europe, people are still in that space, then there is a discrepancy. And then I understand, because it's burdensome, it's complicated to put in place, it's very administrative way of doing things, but we are in the risk-based approach in EU. We are outcome-based. So it's really about understanding what the regulator is looking for. Very simple. The regulator is looking for to put something in place that will not allow some backman to actually use your money. That's it. That's the rule of safekeeping of clients' assets. So what is the easiest way? A third party is warranting that money exists and it's yours. That's the full scope of what we're talking about. Now we can actually coming into details because it's a profession. It's complicated. There are different things to put in place. But the first thing is to understand what it is about. And then it's easy to put in place, design, and in a way that everybody can use it.
It's been probably one of the best analogies for regulation in the financial industry that I've ever heard. The way you put it, the way you made it, related it to everyday products that we used and so forth. Absolutely brilliant. And I think that's a great way to conclude today's episode. What we do for our guests now is I'm going to leave the stage and I'm going to give you time to talk about Deontea and how people can find you and whatever you want to talk about in regards to your company and what you're doing.
Okay. All right. So happy. I hope that I managed to pass on few, to clarify what MiCA is about, and that it doesn't need to be feared, but rather embraced, because it will provide you with first a real edge, against your competition, and as well something that you can actually sell to your clients. Now, what we do, Deontea is a company that we're operating in the UK, in the EU, and a bit in Switzerland as well. And we helping firms to actually understand the regulatory frameworks and specifically how they apply to their specific situation. And, we provide all type of services. You can find us on our website where you find who we are exactly, what type of products and services we can provide. And honestly, don't hesitate to call us. We will always be open to a first discussion to see whether we can help you out, or if you better, first you don't need us or you want to talk to someone else. But really, what I would like to reiterate here is that regulation don't need to be feared, because they are a fantastic tool for a company to really build a sustainable future and expand their business, be it in EU, UK, or anywhere else. And your clients will be grateful to you for that. Our website is www.deontea.com, and otherwise I believe that you can find out on the website that is hosting this show. So now, thank you very much, and hope that you enjoyed this show and the explanation I tried to provide. So thanks and goodbye.
And thank you very much for that. Really appreciate it. So all those watching, thank you for tuning in today at the Tech Behind FinTech. We appreciate you. As I always say, we love your support, whether you send us a message behind the scene, comment, or so forth. Whether you watch this episode live when it airs, whether you watch it the next day or the next year, I want to give my gratitude and thanks to each and every single person that has been supporting us over the years. And we love our returning guests. So Carolyn, thank you very much for swinging by and giving us some insight around MiCA, especially for the audience in the US. They may not be as familiar with all of these EU regulatory standards. So thanks for giving us some insight, and somebody might look at this episode and do further research on their own. And you can get Carolyn's company in our show notes and so forth. you'll be able to find Deontea, and also Carolyn's on LinkedIn as well if you want to contact her. On that note, I bid everyone a good weekend. We are live every Friday, 12 p.m. EST. Cheers and thank you once again.
Thank you very much. Goodbye.
Understanding the technology that powers the money is essential. Knowing the business drivers that inspire how the money is made is crucial. Bridging the gap between the mind of the technologist and the mind of the business is monumental. That is what TBF is all about. Let's start this never-ending conversation. It's time.